But what was I searching for?
If you were searching for financial records.
Okay, and if I'm searching for financial records, then isn't there certain extensions that I'm looking for, like a Quicken extension or a document extension, and as opposed to a JPEG or a PICT extension? And so aren't I just kind of rooting around maybe where I'm not supposed to be?
I would say yes, and I would agree with that assertion, and that's part of the reason where as technology gets more complex, the Fourth Amendment and the rules and precedents that the Supreme Court has used needs to be adapted. It's different if you go into an apartment looking for audio speakers and looking into a coat pocket and finding a bag of contraband. It's not reasonable to look for an audio speaker in a coat pocket. However, on a computer, it's an entirely different situation almost, as you don't know where files are stored or how they're stored. As you said, it would be reasonable and logical to look in Quicken documents for financial records.
Well, isn't that the other side of the argument with today's technology and the extensions and in today's technology, you can hide those files with different extensions?
Yes.
When we walked into the building today, we all were searched, correct? Does the Fourth Amendment apply to the search that was done to us as we entered the building?
I feel that this is a place and we don't have to be here, and so if we are choosing to come into this place, that we need to go under those searches, and so I don't think that the Fourth Amendment applies to this place.
I would say that since this is a federal building, the government has a compelling state interest to conduct these searches and security checks. As an anti-federalist paper, John DeWitt 2, it stated that citizens and people had to give up certain liberties in order to protect other liberties that are deemed more important. And I feel that the protection and security of the building and those in the building with you is more important than the security of your person and your belongings.
If thermal, or the use of thermal imaging and surveillance is merely an enhanced form of open view, would the same hold true for satellite surveillance? You know, from a distance of 150 miles in the air, or in the atmosphere, or out there?
I would say yes. Google Earth uses satellites, and I feel that if you could go to that house and be on that block and see that house with your plain eyes, not inside the house, but just outside on the block, why shouldn't you be able to view it from satellites also?
All right, in other words, are you saying that in light of the fact that the existence of satellite surveillance technology is common knowledge, there is no reasonable expectation of privacy in anything?
You're saved. Don't you like it when that time card comes up? Judge, you have
Sure.
selected here.
You all did a very nice job in the opening in laying out the values underlying the Constitution, or underlying the Fourth Amendment, and the why of the Fourth Amendment is there. We had a good time. I mean, we certainly had a good time. I hope you all had a good time in the discussion time. In terms of looking at some of those issues, they are hard. They are very hard issues to deal with, and it's a difficult situation to think about what a reasonable expectation of privacy is, given the world we're in now, and given the reasons why we're allowed to search. So it's very important for you all to think about those issues, and we do appreciate you all thinking very, very hard and very, very deeply about those issues, because you all are the next generation that's going to make those laws that we, the old guys, are going to have to live under. Thank you.
Judge.
I agree with Professor Chambers that ultimately reasonable expectation of privacy is what it's all about. developing technology makes possible what was impossible before, namely the capacity to observe activity under circumstances that would be utterly opaque in the absence of that advanced technology. And so the question then becomes, are we going to say as a matter of law that therefore our reasonable expectation of privacy is diminished? If we're going to say that, as the question I asked that remained unanswered suggested, then we may have already come to the point where we no longer have any reasonable expectation of privacy, and the Fourth Amendment means nothing. And these are the questions that the courts, the Congress, and the people are going to have to grapple with going forward. And that means that in the front lines of that grappling are going to be you. So good luck to you. I'm glad my work is done. You did a very nice job.
I have to agree with that statement. Good luck to you, because I've begun to grapple with these questions, and it's going to ultimately be you folks who are going to decide how technology and the right to privacy, are going to be married or unmarried. All the technology. It's an interesting question, and how much governmental intrusion is there going to be? Because you put it out there. Our emails, should they really be treated different than an email? Than a mail sent through the postal service? How much privacy is there that you give up? Great participation across the board. We ask these questions. Some of them are hard questions. Some of them aren't good questions. Okay, and sometimes it takes a minute to get on a roll. I think and that certainly happened in this session. Don't ever let that bother you, because sometimes it just we just have to start clicking as judges, and then getting our dialogue. Once we got our dialogue going, it went really, really well. You should be very proud. Okay, good job.